Good morning, everyone. Want to welcome you to the April 23rd meeting of the Juvenile Jurisdiction Advisory Committee, and hope everyone is having a nice day so far. Even though we've had a little weather here a couple of days, didn't feel like spring. First item on our agenda is the committee minutes. I hope everyone got a copy of their minutes and had a chance to read those minutes. If you would, take a second and review those, and then I'll entertain a motion to approve or to make any amendments to it that anybody sees fit.
I move that we approve the minutes.
Okay, we have a motion. Do we have a second?
Second.
Okay, Kim, if you would, take a roll vote.
This is a vote to approve the minutes. Stella Bailey, Jamie Souls for Stella Bailey. Betty Budd. Tara Callahan.
Tara Callahan, yes.
Aaron Campbell. Judge Courtney. Bill Davis.
Bill Davis, yes.
Gary Frank.
Gary Frank, yes.
Beth Freshwater Smith. Michelle Hall. Director Andrew Heath.
This is Judge Heath. I'm going to abstain. I have not had a chance to review the minutes. Sorry.
Thank you, sir. Krista Hyatt.
Yes.
Jennifer Knox.
Yes.
William Lassiter.
William Laster, yes.
Jeffrey Ledford.
Jeff Ledford, yes.
Marty McGee.
Marty McGee, yes.
Carol McManus.
Carol McManus, yes.
Robert Rader. Mary Stansel.
Mary Stansel, yes.
Heather Taraska.
Heather Taraska, yes.
Robert Taylor. Eric Zagra. Vote complete.
Okay, that approves our minutes. And our next item on the agenda is the juvenile justice update, and I'll turn the floor over to Deputy Secretary Lassiter.
Thank you, Chairman Davis. Appreciate it. Good morning, everybody. Hope everybody's doing well, and thank you for attending the Juvenile Jurisdiction Advisory Committee this morning. And we wanted to give you a brief update. I know in the last legislative report that you guys signed off on in January, we provided the first year data for Raise the Age. And so we wanted to kind of give you an update since that report was done, what the data is looking like, and just some of the basic statistics that we're seeing as far as the Raise the Age numbers. And Feel free as we're going through the presentation, if you'd like to stop me or ask a question, feel free to do that, or you can put something in the chat. And I might not see the chat right away, so hopefully Kim, you'll help alert me if there's something in the chat that someone has a question about. But feel free to stop me as we go through the presentation. And the WebEx has changed up the way that they do the presentations. Let me make sure I do this right. Okay. Hopefully everybody sees the presentation. Kim, were we good on your side as far as the presentation?
Yes, sir.
Okay, thank you. So we do have some new members as Kim called the roll today. You probably noticed the new members being called out. And so we want to welcome those new members. And so we've got Ms. Stella Bailey, who's the section chief for the Justice Section and Innovation Section of the Division of Mental Health and Developmental Disabilities and Substance Abuse Services, that has joined our group. This is Rachel actually moved on into a new position, and so she had represented that position for the last 4 years, and so we're glad to welcome Ms. Stella Bailey to the group. Dr. Robert Taylor is taking over and the superintendent's role. This was the role that Kim Martin for many years served in, and as we've got a new superintendent now, Dr. Catherine Truitt. Her representative is Dr. Robert Taylor, and he's over the operational support section of DPI, which includes the Center for Safer Schools, which makes a good fit for what we're looking for from DPI, and we're really glad that he will be joining the group. Met with him last week and kind of gave him an update on where we are with the JJAC, and he's excited to be a member of the group. And then many of you probably already know Director Andrew Heath, Judge Heath, and he is taken over as the Director of the Administrative Office of the Courts. And so we welcome him to our committee also, taking over from McKinley Wooten as we have a new Chief Justice. And Andrew Heath was named the new Director of the Administrative Office of the Court. So welcome to all three of you, and we look forward to hearing your comments and making you part of our committee. So let's jump into what we're seeing as far as the juvenile justice data. And so just kind of want to, we've talked about, we've had multiple things going on at the same time. We had Raise the Age happen on December 1st of 2019. And then in March of 2020, we had the pandemic hit. And so both of those factors have been changing the dynamics of the type of kids that we see in juvenile justice, the types of incidents and crimes that we're seeing in juvenile justice. And so this slide kind of lays out what we're seeing and the differences that we're seeing. The big difference pre-COVID, about 32% of the juvenile complaints coming into the system were for person crimes, crimes committed against people. And after COVID, that's dropped to 20%. So that's been a big drop off as far as the types of crimes that are being committed as far as person crimes. And the other area that we saw a big drop off because of COVID is in that area of public disorder. And that's dropped from 31 to 25%. I'm guessing that the majority of that public disorder drop off has come from not being charged for disorderly conduct at school, which tends to be the top charge in that public disorder category. But the area that we've seen the increase in is in property crimes, significant increase in the number of property crimes that are being committed by juveniles. And so it's a different dynamic than where we've seen in the past. And some of that's probably pandemic related, and some of it's probably also related to this new population that we have in the juvenile justice system through Raise the Age. So 55% are now property crimes. Those are things like breaking and entering, and stealing property, larceny of property, those types of crimes that we're seeing in that category. And so those numbers have gone up significantly. That also may be due to the economic aspects of the pandemic, and we're just seeing that kids are trying to help support their families in a non-healthy way. And so that's probably the other way we're seeing that number increase. The school-based offenses, as you know, one of our subcommittees for many years on this committee has been the School Justice Partnership Committee. And I wish I could say that, man, they're just doing an outstanding job, and that's why this number has changed so dramatically. But I think the real reason is that a majority of kids in our state have not been in school. And so the goal of the School Justice Partnership was to reduce the number of school-based complaints. We are obviously doing that, but I don't think that the only factor that's driving that down is the school justice partnerships. I think a big part of that obviously is the lack of kids being in school. So this is just remarkable, though. If you compare the first 3 months of 2020 to the first 3 months of 2021, we went from 3,798 school-based offenses to 2021 only having 691. So that's about a sixth of the number of school-based complaints coming in to the system as we've had in the past. And just for those new members that we have, a school-based offense is a complaint that's filed on a juvenile on school property or at a school sanctioned event or at a bus stop, for example, or on a school bus. So something that is related to a school. So you can see that these school-based offenses have dropped tremendously. School-based offenses make up about 40% of all complaints that come into the juvenile justice system in a typical year, between 40 and 45% of all juvenile complaints. This year, that's dropped to, the last time I checked the number, I think it was 19% of all juvenile complaints coming into the system. So a huge decrease in school-based offenses that are occurring across the state. That would be really good news if kids were all back in school, but I'm guessing that's the bigger contributing factor. So let's specifically look at raise the age population and where we are on the raise the age population across the state. So in year one, in the first 4 months from December to March, we had 4,060 complaints that were filed on juveniles. Throughout the full year of raise the age. This is just the raise the age population. So this is just the 16 or 17-year-olds, not looking at the 15 through 6-year-olds that can come into the juvenile justice system. We had 12,354 complaints in year one. But just in the same time period that we're looking at, as far as the number of months that we've got so far for this year, we had 4,060 complaints in year one in that same time period in those first 4 months. And versus this year, we've had 3,841 complaints come into the system. So almost statistically speaking, a pretty close number there as far as the number of complaints coming in. That is about a 200 complaint drop from last year. I'm guessing a lot of that, again, is pandemic related in the fact that last year in the first 3 months, kids were still in school. This year, they have not been. So we don't know what the long-term trend line is going to look like yet. But right now, the positive news is that we're not seeing a huge burgeoning of the population in the first 4 months based off of the data that we've gotten so far. So this kind of this next slide shows you that in a timeline for the first full year. There, you've got the blue line that demonstrates the number of complaints coming into the system by month, and you can see that the trend line really kind of matches up almost perfectly from the first year, except we're slightly lower than we were in the first year as far as the number of complaints coming into the system so far this year. And so the same time periods that last year we saw peaks, we're seeing the peaks this year. So those timelines are kind of remaining consistent as we move forward. But again, not a huge drop off in the number of complaints from one year to the next year. So that kind of gives us an idea that hopefully we're staying in line with what we saw in the first year moving forward. The next slide here kind of shows you the number of juveniles that came into the system that were raised the age. Again, this is just the raised the age population, does not take into account the younger population coming into the system. Last year, for a total, we had 4,110 raised the age kids, 16 or 17-year-olds come into the system. And in the December through March time period, that made up 1,738 of those kids. And so far this year, we've only had 1,280 kids. So actually a pretty significant, when you look at the number of kids coming into the system this year, we've actually seen a pretty significant drop off in the number of kids that are coming in. So the complaints haven't really changed that much, but the number of juveniles have changed. That means that our guess there is that more complaints are being filed on one individual child. And so as you may remember from previous presentations, we had projected what we thought that number of complaints per child would look like, and we thought it would be in that between 2 and 3. This is representing that we're actually seeing a little bit higher, closer to that 3 threshold than we were thinking would come in. So for each incident that we're seeing that a child gets arrested for or complaints filed on them, we're actually seeing that they're getting 3 complaints filed on them for each of those incidents. The next chart here kind of shows the number of juveniles. So this shows that same complaint chart that we showed just a minute ago. This shows the juveniles, and you can see that the number of juveniles coming into the system has definitely not reached the same level as we were at last year, although the complaint number is still significant, almost on path with the last year number. The actual number of juveniles coming into the system has not hit that same level yet. As you can see, last year in the March through May time period, we saw a significant drop-off in the number of juveniles coming into the system. That was definitely related to COVID. And so we're still really kind of wrapping up COVID, hopefully. Knock on wood, we're almost to the end of this whole thing. And so it will be interesting to see as we enter that March, April, and May time period, whether or not these kids start to go above what we saw last year, since we're kind of edging out of the COVID path that we were on last year. What about detention? This is just, again, the raise the age population, the 16 through 17-year-olds. When we look at detention and the number of kids that came into the system. So the first number up at the top shows you the number of intakes. What is intake? That's the number of actual events of kids coming into a juvenile court counselor's office for a complaint being filed against them. Within 1 year, a kid can come more than once because they would have a complaint filed on them in January and then a complaint filed again maybe in August. So this doesn't represent the true number, just the number of individual juveniles that came into the system. This is the actual number of intake events that we had with a law enforcement officer bringing a complaint on a juvenile to our office. So there were 5,385 of those intake events. Of those 5,385 intake events, 609 of those juveniles were sent to detention. So there were 609 detention admission events that were precipitated from those 5,385 kids coming into the system, or intake events occurring. On average, that occurred within 8 days of intake. And so most of those detention events were caused by that intake event, and not necessarily a disposition of the court, but while the kid was awaiting trial, or it could have been, it could also be something that the judge was ordering in those cases. But you can see within 8 days is normally when those detention admissions occurred. So that means about, for all the kids that come in, as far as an intake event, that 11% of the intakes ended up with a kid going to detention. And so that was 77% of what we projected as far as detention admissions. And the actual percentage itself is a little higher. We weren't projecting that quite 11% were going to end up in detention based off of past behavior that we saw with 15-year-olds. So more 16 or 17-year-olds are going to detention than we saw for the 15-year-old population. But that seems natural to us because obviously with older kids, you've got kids that are more risky, may have more past delinquency history, and that is probably precipitating this higher 11% number that we're seeing in this category. But again, it's still less detention admissions than we originally thought would come into the system. And then, so far this year, in year 2, you can see so far we've had 1,558 intake events. 202 of those have ended up with kids going to detention. That still is within that 8-day time period that we're seeing. But that percentage down there in the pink box, you'll see, has grown from 11% to 13%. So of the kids that are coming into the system right now, as far as an intake event, about 13% of them are ending up in detention, which still means that of the events that are occurring, intake events that are occurring in the juvenile justice system, 87% of those raised the age population are not going to detention based off of the intake event. And that right now we're hitting 85% of the projected admissions for the year. So that's slightly higher than last year. And as we discussed at the last meeting, the big issue for detention is that we're getting a lot of the transfer population. The bill that was passed last year, House Bill 593, basically said all kids under the age of 18 must stay in a juvenile facility until they turn 18 years old. So a lot of the kids, even after they're being transferred, are now staying with us in a juvenile facility until they turn 18. Those juveniles are staying much, much longer than the typical juvenile that enters the system. So what we're seeing is a average length of stay that is continually growing because of that transfer population. Really not because of the juvenile population that's in the facilities, but because of the transfer population that's already been transferred to adult court and is awaiting trial at Superior Court for their crimes. So this shows you the transfer population itself, just so you have an idea of what we're talking about. In the past, we've barely ever transferred kids to the adult system. North Carolina had one of the lowest transfer rates in the country as far as transferring juveniles into the adult system. And you can see in 1920, as far as, and this was the non-raised the age population, we had only 20 transfers. Once we added the raise the age population and the A through G automatic transfers to adult court, obviously that number is going to go up because you have automatic transfers, where in the past that automatic transfer category was just for A felonies. Now you've expanded the categories for these 16 or 17-year-olds to include A through G felonies. Obviously, you're going to have a larger number of transfers occurring, and that's exactly what we've seen. 249 transfers last year. For the raise the age population, overall we had 273. So you can see that the vast majority of these are for the raise the age population, not for the juvenile population that would have been there before raise the age, the under 16-year-olds. There are only 24 of those transfers that occurred. And I know a lot of people have had a lot of questions about the raise the age, the transfer kids and what they look like. So we're going to give you a little bit of demographic data on the transfers and what that's looking like across the state. And we've got several bills that are pending in the General Assembly that take up this issue of transfers that we'll talk about in a few minutes also. And that's why this transfer population is important. So overall, to kind of give you a picture of what type of kids are coming into the juvenile justice system for the raise the age population, versus the non-raise the age population. You can see the blue bar there is the non-raise the age population, so under 16 years old, and the red bar is the 16 or 17-year-olds for each of these categories. And you can see for that first category, African-American juveniles make up a vast majority of the kids coming into the juvenile justice system, both for the non-raise the age population and for the raise the age population. But we do significantly better with the non-raise the age population. If you're thinking about African Americans being a percentage of the population in our society versus the percentage that are actually coming into the system. So 57% of non-raise the age population are African American youth. But when we get to the raise the age population, it's 67% of all of the juvenile complaints coming into the system are for African American youth. Obviously, this is an issue that we need to look at and try to figure out how we can do better at reducing that disproportionality, especially when you're talking about a population that makes up only in the 20% category of the population in our state. This is a huge disparity between what we're seeing coming into the system versus what is in our society. And you can see the other categories there and how they break down. So for Hispanic youth, the raise the age population and the non-raise the age population are both 11% of the population. Of the other population, which would include Pacific Islanders and Native Americans, they make up about the same amount, and at 8 and 9%. The change really occurs with the white or Caucasian population, where you can see 24% of the non-raise the age population are white versus only 13% of the raise the age population. So here's the most serious offense that caused a juvenile to be transferred to the adult system. And this is just, again, the raise the age versus the non-raise the age population. And you can see the reasons why kids are being transferred to the adult system. Again, A through G's, if you're over the age of if you're 16 or older, that's an automatic transfer. So that you would expect that the A through G's would be the categories that are causing most of the transfers to occur. And sure enough, that is the case of what's happening. And so you can see kind of the breakdown there. For the non-raise the age population, Class A felonies are still automatic transfers all the way down to the age of 13. And so for most of those Class A offenses there, they fell into that category and were automatic transfers to the adult system also. But you can kind of see this breakdown of what's occurring. We did have some H&Is that were transferred to the adult system. Those are not automatic transfers, but the statute does allow for 16 or 17-year-olds that commit H or I felonies to be transferred to the adult system. They must go through the normal transfer hearing process, just like the under 16-year-old population would have to do in the system.
Billy,
Yes.
just a quick question. I just want to make sure I'm reading this right. So in 2020, there was no 13, 14, or 15-year-old transferred to adult court for armed robbery because there was no D's. Am I reading that right?
You are reading that correctly. Yes, sir.
How much, I mean, how much do you think that has to do with the pandemic versus the change in the law for raise the age, if you were to guess?
Well, as I stated earlier, Eric, we have very few kids under the age of 16 that get transferred to adult court. And so I think if you went back in time, I don't think that category would be very high even for the last few years. We average less than 20, around 20 or less transfers total each year to adult court for kids that are under the age of 20, I mean, under the age of 16. And so I just don't think that there's been many of those in the past either.
Thanks.
Mm-hmm. So of the H&I felonies that got transferred, just kind of break it down for you because I know those are the discretionary ones that occur. We only had 11 juveniles that fell into that category that were 16 or 17 years old, committed an H or I felony, and were transferred to adult court. Of those, 10 of those juveniles were 17 years old. Only one was 16 years old. So we only had one 16-year-old that committed one of the H or I felonies and were discretionarily transferred to adult court. So that's not happening very often. Just wanted to make that point. It's really the automatic transfers that are causing kids to be transferred to adult court, not the discretionary ones. And of the people that are being transferred to adult court, again, there's definitely a racial disparity here in those numbers. 70% of the kids being transferred to adult court are African American. Again, a huge percentage there of the total transfers. And one thing I would say is this, again, is preliminary data because there are quite a few kids in that first year that were pending transfer still that had not been transferred yet. As you know, we recommended in the General Assembly put in place that kids could, that we could delay the process of that transfer up to 90 days while people were doing their fact-finding missions on those cases to really determine whether those cases needed to be transferred to adult court or not. And so we had quite a few kids that were still pending whether they'd be transferred at the end of the year. So I think some of these numbers will grow once we get the final decisions on those transfers. But I wanted to give you the preliminary data of what this is looking like as far as those juveniles being transferred to adult court. So there are a couple of policy decisions and proposals that we're working on, trying to think through that data, obviously with the huge discrepancy between what we're seeing with African-American juveniles entering the system and how they're ending up in the system. It creates a lot of questions in our mind about how can we do better and what can we do to address that population moving forward. to not cause them to have to end up in a situation where they're being transferred to adult court. And so I'm going to let Kim talk real quick about some of the research collaboratives that we're working on as part of those policy and research moving forward. So Kim.
Yes, sir. So we have active collaborations with learning institutions as well as completing some internal research by the JJ section. The first collaborative is with NC State, where students are examining the front end of the system, complaints and risk needs as it relates to racial and ethnic disparities. We're also beginning to start a project with UNC Chapel Hill regarding the deep end of the system, examination of racial and ethnic disparities in secure custody. And then internal to JJ, we are looking at DHHS's research on internalizing versus externalizing diagnoses and race group relations to that, to see if we are able to verify their findings with our data. And so we expect decision points from this research to help inform training and policy for juvenile justice.
Thank you, Kim. So we're really excited about all three of those initiatives, and I think it's going to give us some more information about how we can really think through and plan and see what we can do to really deal with the red issue, is what the feds are calling it now, the racial equity disparity issue within the juvenile justice system, which obviously carries over to the adult system. If you look at their data, it's not any better moving forward with the adult population. So we really want to try to come up with ideas that we can address these and address them early, because by the time a kid is getting the A through G felony complaint filed on them, is too late in the process to really try to do something to prevent that kid from deeper involvement in the system. So really looking at some of the Safer Schools initiatives that we can do, what are some additional resources that may be needed in our schools to prevent those things from happening. And you can see that's the last bullet point down there is really working on the Safer Schools Task Force. They will be meeting next week, next Wednesday, and really talking about the curriculum for SROs, for school resource officers, and additional training that may be needed, and also working on the SRO memos of understanding with that delineate what are the responsibilities in the schools for those school resource officers. So that's a topic for the Safer Schools Task Force. It was a recommendation that also came out of the governor's task force on racial equity that this be looked at, and it was tasked towards that Safer Schools Task Force. I share that task force and would certainly appreciate any input that you all would like to put into those discussions moving forward. The diversion program expansion and access, we're actually doing a second diversion study right now that's looking at the diversion process in the juvenile justice system. Is it equitable? Who's getting the diversions offered to them versus the kids that are being approved for court? But also looking at how do we expand access to the diversion plans and contracts. And the reason why we're looking at that is because so many kids are being successful on those diversion plans or contracts. The Sentencing Commission, I don't know if Michelle has joined us yet or not, but they're getting ready to put out their recidivism report, and the recidivism report on juvenile justice looks really good for the data that's just recently going to be released, and actually shows that kids that are put on those diversion plans or contracts do extremely well and don't recidivate for 2 to 3 years after in the follow-up studies that are done on those juveniles. So if it's working and we're seeing those good results, that's a factor of two things. One, that we're putting the right kids in, but also two, that the programming and the contracts that we're setting up with those kids are effectively addressing the reasons that they came to the system in the first place. Minimum age and implementation of services. We'll talk about minimum age in a few minutes. Obviously, it's one of the topics for the Juvenile Jurisdiction Advisory Committee today, but we are working with some of the foundations out there to work on if there's ways that we can increase services for this younger population to make sure that they're served by things that are more appropriate than the juvenile justice system for serving that younger population. So We're working on implementation of those services. But also, if the legislation does pass this year, there's a child consultation process that's set up in that legislation. So we've already started to work on how that would work in our system. How would we make sure that we would have a firewall between child consultations and any other juvenile justice data that's tracked in NC Join. So we're starting all that process. And we're also looking at implicit bias training, but also just the juvenile minority sensitivity training process itself. We had a bill that did pass the General Assembly, the House, unanimously already. That's going to allow for us to have more authority over the training that we provide our juvenile justice professionals in our system, to make sure that they are really focused on how do we reduce those disproportionality numbers that you guys saw earlier in the PowerPoint. And so glad we got bipartisan support on that to really try to push forward how do we address that training more appropriately for our staff moving forward, to try to reduce those numbers. So those are some of the policy and research things that are going to come out of the data that you've seen so far. And we're certainly open to other ideas or concepts that you guys think we need to address based off of some of the data that you've seen so far. The good news overall, to kind of summarize everything, we're not seeing an onslaught of new kids this year versus last year. The numbers are holding steady as far as the number of complaints, and are actually a little bit lower for the number of kids that are coming in, 16 or 17-year-olds. That's a good sign that we're not going to see just a huge blow up as soon as the pandemic is over. We do still project that there will be an increase, obviously, as schools are starting to go back into session. The data that you saw today ended in March. Most schools started back in the state of North Carolina within March or April. And so we'll need to see what that data looks like in the next couple of months here to see really what the overall impact will be of that population returning. And still, there's a lot of kids that are still on virtual academy or virtual services for schools. So we may not see the full impact until August or September of next year. So I'll be glad to take any questions about any of the data or any of the things that were presented in the presentation.
Billy, I've got a quick question. Do we have any data on the kids that were remanded?
We can get that for you. The last time we checked, Eric, it was only 20, I think it was 21. Is that right, Kim? Do you remember off the top of your head?
That sounds right, sir.
Yeah, we were averaging about 2 a month as far as being remanded. And so for those of you that are new to the committee, just to explain what remanded means is there are automatic transfers for A through Gs. And there's a process that was put in place by our recommendation that the legislator passed last year that allowed for, if the defense attorney and prosecutor both agreed that that was a case that needed to be moved back down to juvenile court, that could be done. And so what we've seen so far is that it's being done, but very limited across the state. And the last time I saw the number, Eric, it was 21, and we were averaging about 2 a month of those remands.
If it wouldn't be too much trouble, I appreciate what you did sort of on the front end, breaking it down by offense class and demographics. Would that be possible to do it on the remanded kids as well?
Sure can. We can do that. We can get that data for you.
Thank you.
And just so everybody also knows, we made a recommendation that there's a bill pending already that would allow for the prosecutor to basically have that authority before it even goes up to Superior Court, for them to have prosecutorial discretion to keep that case in juvenile court. There's different versions of that bill, and Justin will talk about that in a few minutes during our legislative update. Any other questions? All right. If not, I'll turn it back over to you, Chairman Davis.
All right. Thank you, Deputy Secretary. Appreciate the information and the PowerPoint presentation. And I think that information, the PowerPoint and everything, Kim, we can make that available to everybody so they'll have that.
Absolutely.
All right. Thank you. That'd be great. All right, on the agenda is the legislative update, and Justin Davis is going to take care of that for us, and I'll turn the floor over to Mr. Davis.
Good morning, everyone. Happy Friday. It's good to be with you today. So I want to jump right in here. I'll direct you to some of the meeting materials that Kimberly Quintus sent out earlier this week. In fact, I'll pull that up here with you. So there was a legislative update that went out that kind of shows the breakdown of bills of interest. You can click on the link where the short title is. That will pull up the bill page where you can get more information on each bill. So just want to point you to that. So that'll be kind of where I'm following during my presentation. So real quickly jumping into things, House Bill 252, that was a bill that includes recommendations that was provided by this committee. It includes those from the January 2021 report that we sent. And so just to remind you of what was included in that report, that dealt with some of the conforming changes to YDC extended commitments, also dealt with some changes to the post-release supervision area of law, also juvenile transfer housing changes in response to House Bill 593 that was filed that was in the 2020 session. Also looks at secure custody order issuance upon remanded cases. If you recall, there was some clarity that was needed as to which court would be responsible for issuing those secure custody orders when a case was remanded back down. So that was included in House Bill 252. We also saw added to it, we had added to it prosecutorial discretion. However, 252, that includes prosecutorial discretion for E through G felony cases in juvenile court. I know that the JJAC, their preference really was A through G, and we try to work with legislative members to get that done, but I don't think they were quite willing to go quite that far. But right now we have it as E through G, so that's a good start. We also saw added to it in a PCS, proposed committee substitute, kind of late in the game. We recodified General Statute 20107. To remind you all, that was the tampering with a vehicle, motor vehicle offense. We had that moved over, recodified to Chapter 14 offense. And so happy to get that in there. That passed the House last week, 115-1, and now awaits the Senate. And so, and I'll get to this a little bit later, but the Senate, really their primary focus right now is the budget. And so we expect things will start moving a little faster once their budget's released. Next on the list is Senate Bill 207, while the short title is identical to the House bill I just discussed. Despite the title, not all parts are JJAC recommendations, and so we made sure we let members know about that. That bill includes all components of House Bill 252 that I previously discussed, with the exception of recodifying General Statute 20107. And so when this bill actually was moving, we were still in the process of working with DMV to address their concerns about the enforcement side of things. They were concerned that with the change, if they didn't have any changes to their portion of the statute, their License and Theft Bureau may not be able to enforce that law anymore. So we work with our partners at DMV and have that change also made. This bill also provides pretty notable part. You probably saw this in the news, probably read about it some places. It wasn't actually a JJAC recommendation at the time, but this bill contains provisions related to changing the minimum age of juvenile court jurisdiction. That would change only for delinquents, though. It does not address undisciplined youth, but it would change that age from 6 to 10 years old. And so also in that bill, it kind of gave what that mechanism for compliance of not attending services. So the bill provides language for child consultation services and gives juvenile court the exclusive original jurisdiction over parents of children under the age of 10 who's receiving those consultation services. And so we've heard, there are some concerns about the constitutionality of what that looks like. There are some that are saying that Perhaps, how can you have, I guess, jurisdiction over the parent when you don't have jurisdiction over the child involved? And so that's been an issue that's been raised. Nonetheless, that bill passed the Senate 45-0 in a unanimous vote about a month ago, and now it awaits movement over in the House. So those are really the big two JJAC bills that you'll see on the list. Also included on this list is House Bill 225. This bill would provide prosecutorial discretion for keeping A through G felonies in juvenile court. And this really reflects what the JJAC's preference was. However, this bill has been sitting idle in committee for since about early March. I think with the passage of Senate Bill 207 and House Bill 252, I'm not sure I see this bill really advancing any further. I think the reason for that is it would have to be approved by 3 committees and get a floor vote with less than 10 days before crossover, which that date falls on May the 13th. Next on the list, House Bill 261. This bill would raise the minimum age of juvenile court jurisdiction from age 6 to 10, and this would include delinquent and undisciplined youth, which would be needed. This also provides for those child consultation services like Senate Bill 207. However, rather than the court having jurisdiction over the parents, this bill will instead route instances of consultation services, the non-compliance side, that would route it through the DSS neglect process. However, since that bill was heard in committee several weeks ago, there's been some opposition voiced for routing those cases of non-compliance through the DSS process, mostly on the sheer basis of, does that constitute neglect? If a child is not attending those services, can you have the parent be held responsible for that child in a neglect type of situation? So this bill, again, it may have some challenges. The bill would have to move through 2 more committees and a floor vote before the crossover deadline. And right now it currently sits in Judiciary 2. A little further on the list, getting a little bit outside of the JJAC direct bills, but these are some bills that are probably of interest. So House Bill 173, this bill would separate DPS's Division of Adult Correction and Juvenile Justice into 2 separate divisions. So juvenile justice was a standalone division, if you recall, back in about 2013 timeframe. And it was actually, at that time, under different DPS leadership, it was seen as a measure that could, by merging the 2 together, adult correction and juvenile justice, that there would be some efficiencies realized. However, over the course of years, those efficiencies never did materialize. The 2 were actually coupled together in legislation back in, I believe it's 2017. Together, our hope is to break them back out as 2 separate divisions. And I think that really this, we're looking to clear up some ambiguity as it relates to the handling of juvenile and adult populations. I think obviously there are differences in juvenile and adults in the system and how they're treated by the system. So this bill is something that was something the Department of Public Safety actually is pushing for. And the bill was heard in House State Government about a month ago, and it's assigned to the Appropriations Committee. So don't be surprised if you do see it maybe in a budget bill. Also, it is to make that move, it would require some additional appropriations in a couple of positions. Those were included in the governor's budget that would recreate a division of juvenile justice. And so we're excited that that's also in the governor's budget. Next on the list, under Deputy Secretary Laster, talked to this a little bit about implicit bias training. House Bill 183 was also, as you see, indicated by the AB in the short title, is an agency bill. This would basically allow juvenile justice to develop its own training Currently, juvenile minority sensitivity training that's required is really, it's designed more for law enforcement. This curriculum is provided by the Justice Academy. And so this proposed legislation would allow the juvenile justice section the right to develop a training curriculum that reflects the needs of its staff. And of course, we have a lot of data to back up kind of where the training needs are and how that would look. Like Deputy Secretary Laster said, that passed the House unanimously, 119 to nothing, about a month ago, and right now it awaits its fate in the Senate. And also want to add another bill that didn't make it onto the list, and that's frankly because when this list was created on earlier this week, the bill hadn't been filed at that point in time. But House Bill 615 was filed earlier this week. This bill was filed and reflects language provided by juvenile justice, and really it addresses a pressing need. So there have been a few Court of Appeals opinions where the juvenile dispositional orders have been vacated on the basis of trial courts failing to direct a mental health assessment between adjudication and dispositional hearings. And so what this bill would do would amend 7B 2502 language, which pertains to the evaluation and treatment of undisciplined and delinquent juveniles. And really, it focuses on cleaning up some of those antiquated laws that reflect terms such as area mental health director, which really is a term, I guess, that was used more in the 70s and 80s when some of this language was first written. The bill would also provide some language for establishing care review teams that would review the needs of juveniles post-assessment. And so without really discussing that one a whole lot more, I will direct you to the super knowledgeable Jackie Green with the School of Government. She has authored a blog post on it about 2 years ago, this issue, and can probably answer any questions you may have about that. So as for bills, that kind of concludes my list of that. Lastly, I'll just add that we anticipate the Senate to release their budget here within the next 2 weeks. We hear that they're getting closer. I know some of the subcommittee chairs are starting to present the subcommittee budgets list of things to the big appropriations chairs. And so typically also looking back when the Senate has gone first in crafting the budget, I think the last 2 times their budgets have come out sometime in mid-May. So I would expect between now and say Mother's Day, somewhere in that time frame, you'll see a budget coming out. Pretty close to probably the crossover deadline. So that concludes my comments. I'm happy to take any questions. If there are any questions offline that you want to address, feel free to shoot me an email at the bottom of that update, and I appreciate the opportunity to provide a legislative update to the crew. Thank you.
Okay, thank you, Mr. Davis. And is there any questions, Mr. Davis? Okay, if there are any questions, we'll move on to the next item on the agenda is Indictment for Youth and Jackie Green with the UNC School of Government. I'll turn the floor to you, Green.
Thanks so much. Hi, everybody. Heather, did you want to say something before I get rolling?
Sure. Good morning. Just wanted to say that one of the issues that the Legislative Revisions and Legal Issues Subcommittee identified was gaps in the statute surrounding the indictment process. And Jackie organized a work group and drafted language to fill the gaps. And she's going to present that information to you now, basically the work of the work group.
Thanks, Heather. And Kim, I know you're going to pop it up on the screen for me. While that's happening, I know we have some new folks. So I think a lot of us have been enmeshed in this, and we're like, oh yeah, let's talk about the indictment process. But let's to get everybody on the same page, so you know what the heck we're talking about if you're new to this group and this meeting. The legislation that raised the age created something brand new that we never had before in the context of juvenile court, and that is that for A through G felonies alleged to have been committed by folks at age 16 and 17, there is the possibility of the mandatory transfer. Those are all mandatory transfer cases, and there are two ways to trigger that transfer. One is a finding of probable cause, and that had always been the way that transfer was triggered in the juvenile law, so there was nothing new about that. But the new thing was one sentence in the new law that said the return of an indictment can also trigger the mandatory transfer of those charges. And there was really no procedure put in the law about what that was supposed to look like, how that was supposed to roll. And there has been a ton of confusion and many, many questions about how that's supposed to function. So the work group came together to talk about, initially we were going to talk about two things, but a third came up while we were working. And so we have some draft language to address all of them. One is what is notice, what notice is required. The second is there a hearing required? And if so, what needs to happen at that hearing? And then the third thing that came up was trying to reconcile what's in the existing criminal procedure law about when an indictment can be brought to a grand jury. So I'm not seeing the language on my screen. Are you, Kim, are you sharing that language and I'm just not seeing it, or is it not up there?
I'm sharing it, but y'all cannot see it. So we're working behind the scenes to fix that real quick.
Oh, okay. So I'll just talk about it and then hopefully eventually you'll see it. So let's talk about notice. Oh, there it is. Awesome. Thank you. So the statute right now makes reference to notice. You see that here, right? So this is the one sentence. You are now seeing the entirety of the law about indictment. 7B 2200.5A1 is where the indictment is thrown in, and it already talked about notice, but people didn't know exactly what notice meant there, because notice is required in that other way that we transfer cases through probable cause. And in that context, it's very clear what notice means because you're waiting for a finding of probable cause. So in that context, notice has meant that you're going to seek transfer. And that's the only thing to give notice of in that context. But in this context, it could be notice that you're going to seek transfer, but it could also be notice that the bill of indictment has been returned. And that's what the work group decided should be the clarifying language in here. So that just clarifying that notice means it's notice that a bill of indictment has been returned against the juvenile. So that's the first piece. That's what notice would hopefully clearly mean if this language were implemented. The second piece is what's the hearing? Can you scroll down a little bit, Kim, so we can see the hearing language? So the statute right now does not say there has to be a hearing. And that gets to be problematic because there are two big things that have to happen at the time that this transfer happens. One, there is a finding that the court has to make. The court has to find that one of these indictments has been returned against the juvenile. So an indictment alleging an A through G at age 16 or 17, that is the finding the court has to make. And once that finding is made, the case must be transferred. That's why it's mandatory, right? The case must be transferred. Once that transfer happens, the court needs to quite immediately determine conditions of pretrial release, because we now have a young person who has moved from being under the jurisdiction of the juvenile court in a juvenile matter, and if they're being held pursuant to a secure custody order, which is the way we hold kids in juvenile matters if we're holding them. Now it's a criminal matter. And so that secure custody order, if you have one, is meaningless because you're not under juvenile jurisdiction anymore. You need conditions of pretrial release to be set as they are set in any criminal matter. And the juvenile code already says that at transfer, conditions of pretrial release need to be determined. So when a court is ordering transfer pursuant to this indictment, they need to make their finding, and then they also need to address conditions of pretrial release. So as a group, we felt like that really needs to be a hearing. The young person needs to be there, their lawyer needs to be there. There might be an argument about conditions of pretrial release in that moment. So this draft language would create a pretty streamlined and short indictment return hearing. To be clear that people need to all come back together, the court needs to make this finding, and then tying that to the existing statute about determining conditions of pretrial release. And I'm not seeing that on my screen. Kim, are we having scrolling issues?
Jackie, I think the new version of WebEx allows individuals, once you've got the document up there, they can scroll on their own now.
I can scroll that? Oh, that's magical.
Yeah, I just learned that today too.
All right, and I rarely use WebEx. All right, so there it is. So there's the indictment return hearing. It is, again, just for these A through G felonies at age 16 or 17. It does put the 90-day timeline on that. So that's the timeline that exists right now for probable cause. If you're going to choose to trigger the transfer, not with the indictment, but with a finding of probable cause, that's the existing timeline. So it just mirrors that here. And it allows the prosecutor and the juvenile to be heard. It's clear that the juvenile gets to examine the returned indictment, which they really should already have, because now we know they're supposed to get notice of that. And then here's the finding. That an A through G has been committed at age 16 or 17, that's what's alleged in the indictment. And then this is the link right here, GS7B 2204, to the statute that already tells them to now determine conditions of pretrial release. So that's the hearing, that's thing 2. Here's thing 3. I will tell you thing 1 and thing 2, we had unanimity among our working group members about that language. Thing 3, we did not have unanimity. So I'll show you what we have here, which is a majority of folks we're comfortable with. And this is the issue of solving the problem of right now 15A 627. So now we've shifted to the criminal procedure law, because the whole indictment process and the grand jury process is not a creature of juvenile law. It's a creature of criminal procedure law. So all the procedure about that is in 15A. And right now, 15A 627 lays out 2 situations in which a prosecutor may submit a bill of indictment, or even must submit a bill of indictment in the context of cases that are under the jurisdiction of the superior court. But what's happening in these juvenile cases is the case is not yet under the jurisdiction of the superior court. It's a juvenile court matter. The case is under the jurisdiction of the juvenile court, and the prosecutor is going to the grand jury with the indictment to get the returned indictment to trigger the transfer. And the juvenile code's very clear that that can be happening. What really should have happened in the initial legislation is that the criminal procedure law should have been changed to also be clear, to mirror that, right? So now there's a new situation in which a prosecutor can submit a bill of indictment to the grand jury. And this is it. It's the same thing we've been talking about. It's an A through G felony alleged to be committed at age 16 or 17. So this just says the prosecutor can submit this indictment to the grand jury. What was controversial in our working group is the second sentence in here. The second sentence reflects what is already in statute in 7B 2203C, which says that once one felony in a juvenile matter is transferred, superior court gains jurisdiction over that whole transaction. And the language you see here is exactly the language that's in the juvenile code. It's the same act or transaction or a series of acts or transactions connected together as part of a single scheme or plan of that felony, right? So it's the whole thing. Like kind of everything moves. Once one felony moves, the whole thing moves. So there have been a lot of questions from prosecutors about what they can put in that indictment. And whether they're going to have to, if they can't put everything in the indictment in the first instance, they would have to go back to the grand jury a second time in that case following transfer. Because when they get to superior court, they need the indictment over all the offenses. So this language clarifies that they can include all the charges for the act or transaction or the single scheme or plan of the felony, the whole thing. In submission of that original indictment to the grand jury, even though that would be more than an A through G. You have to have the A through G in order to submit the indictment, but you can put everything else related to that transaction to the grand jury in that indictment in one effort at the same time. And we also, I just want you to know, have some case law, a case called State versus Jackson that was decided in 2004 based on the statute in 7B 2203 that says that after a case is transferred, charges that were not alleged in the juvenile petition can be added as long as it is based on the same language, the same act or transaction or series that's connected as a single scheme or plan. So that was the clarifying language that most of our work group was okay with, but not all of our work group. And I want to just give time and space if there's anybody else who wanted to offer a different opinion about this last bit of language to pop in.
So this is Eric. So yeah, I'm opposed to that second sentence of subsection C for two reasons. One, you know, my understanding of the law, and I understand State versus Jackson, is to say that back before Raise the Age, once a case was transferred, you could indict in Superior Court on anything that had to do with the offense, whether or not a petition was filed. That's perfectly fine. My concern is that when we created this new law, the process had been altered. And so now a petition has to be filed, then it goes to the grand jury, then it's transferred, then it goes to Superior Court. And that's the way I understand it. So it's my belief that petitions have to be filed at a minimum that's going to the grand jury. Now, that's just the petition issue. The policy issue that I have a problem with is that when you start to present to a grand jury on the juvenile level, and again, I'm only talking about juvenile court, something other than the A through G offense, you're starting to present a picture of the juvenile, him or herself, not just the offense. And when you start to do that, I think you're kind of getting into discussions about the nature of that juvenile, and there's no opportunity to address any other issues about that juvenile like you would in a transfer hearing, their age, their relative, you know, their developmental stage, mental health, that kind of thing. So that's why I have a problem with that part. And so, you know, my, you know, if there is a recommendation, it would be to, you know, add words about a petition being filed, and I'd be more okay with that than what it is. But those were my two issues with that language.
So I don't know if anybody else on the work group wants to comment. That's the sum total of the language we came up with. I'm not sure how you want to move forward from here.
So I think that because this language came from a work group and not from the subcommittee, we don't have an affirmative vote from the subcommittee, that at this point, if we called for a vote, it would have to be from the full JJAC, and it would require a second. Kim, am I thinking correctly about this?
Yes, ma'am, that's correct.
Okay, so I guess at this point, I would like to call for a vote, and I will make the motion to adopt the language as Jackie's presented it, and I don't know whether or not there would be a second, but that would be my motion.
Okay. So your motion would be to approve it as it's written in the information that's been shared with the board, right?
Yes, sir.
Okay. All right. We have a motion on the floor. Do we have a second of that motion?
I'll second.
Okay. Have a motion and a second. And is there any further discussion or questions that anyone else on the committee might have?
Yes, Mr. Chair, this is Robert Rader. I have a question, and
yes,
hopefully Jackie can answer this. And it really relates not to the third part, which is more issue. On the second portion, under indictment return hearing, subsection B, the hearing shall be conducted within 90 days of the date of the juvenile's first appearance. I know that tracks the language of what's in the statute now for probable cause hearings. The indictment return hearing, as I understand it, it is not triggered until an indictment is handed down. Is this placing now a restriction of 90 days to get the indictment done? Because it seems to me like you get in the scenario where grand jury hands down a bill of indictment on the 91st day. You immediately schedule the indictment return hearing, and then someone says, well, you know, sorry, the hearing was not set within 90 days of the juvenile's first appearance. So therefore, I'm not sure what the consequence would be, if any. But it just seems to me like that should be tied to when the indictment is handed down, not to the juvenile's first appearance. But I'd be interested in your thoughts on that, Jackie, or anyone else.
Yeah, and we talked about that a bit as a working group. I think the rub is because the statute requires the PC hearing within 90 days, you functionally have a 90-day limit. And I think the way people have been handling this in practice is if they don't think they can get an indictment within 90 days, they go ahead and do probable cause. So was that somebody else, or was that me hearing an echo? I couldn't tell if it was Heather. Okay. I also think the good cause language in here is helpful with the issue you're raising, Judge, because there is an ability to continue.
But you wouldn't schedule one until you have an indictment.
Well, I think the way folks have been doing this is actually they often do schedule the proceeding with the knowledge of when their grand jury is meeting. That's my understanding. Any of you guys who are doing this in the real world, you know, tell me that that's not the case. But that's my understanding of how folks have been doing it. And I also think the last thing I would just say is you raised the issue of what if you miss the date? My sense of that is that this is not jurisdictional, and it would probably be harmless error, is my sense of that.
Okay.
What our courts are doing right now in Wake County is if we hadn't reached it within 90 days, the court allows the continuance for good cause and puts that on the we're not ready, so they continue the probable cause hearing. And then when we know that it's going to grand jury on a set date, we set and our grand jury is Monday and Tuesday, so we set the return hearing for the Thursday after grand jury. But our courts are allowing the continuance for good cause when it is obvious we're going to go past the 90th day. So as long as that sentence stays in here, the second sentence that the court may continue the hearing for good cause, that hearing I think refers back to either an indictment return hearing or a probable cause hearing, that addressing the issue of transfer has been for a youthful offender has been continued for good cause. So that's how we're getting around if it's not by the 91st day, we've missed something.
Okay, any other questions or discussion?
I don't know if Heather or Jackie would want to speak to what Eric brought up as a point, and the reason why I ask is because I think they can articulate it better than I can. But my understanding is if the other complaints are not necessarily moved up, then there's no room for negotiating to a plea deal for a lower type of incident for the juvenile. So it could actually harm them more by not having some of those other additional complaints moved up. And is that right, Heather or Jackie? And is that a good reason for not doing what Eric was just describing or not? Someone else can answer that better than me.
Well, I think what Eric's talking about wouldn't change what you're talking about, Billy. So the reality is, given the statute that we're not talking about changing, 7B2203C, once you transfer one felony, the whole matter goes. And that is important for plea bargaining in superior court. You don't want to take away the lesser offenses and somehow hold them back, because then if you got to superior court, the kid would have nothing to plead to, right? So you could really be disadvantaging a defendant by doing that. And I think that's what you're referring to. I don't think what Eric's saying would change that. I think the issue that Eric is raising, and it's an issue that I get a lot of questions about, is when can the prosecutor go with an indictment to the grand jury in a case that's sitting in juvenile court, and what can be in that indictment? Does there have to be a petition filed in juvenile court, and can what you take to the grand jury only reflect what is in the petition? And it is very unclear what the answers to those questions are. Now, there isn't law right now. I mean, right now, when you think about outside of this world, when you think about how grand juries work and how prosecutors take things to the grand jury, they are not constrained in some way that you can only take like part of a case to the grand jury in the first instance. They can take whatever they want to the grand jury in the first instance, and they have to. What gets very confusing is the charging document in superior court is the indictment. So when a case gets transferred, anything you're going to proceed on in superior court has got to be indicted. The question that Eric is raising is, does that mean for that initial indictment, it has to be in the petition? What this language here would say is that the only thing that you're gonna, actually, this language doesn't talk about a petition at all, right? This language just says, when there is an A through G felony alleged to have been committed at age 16 or 17, that whole transaction can go to the grand jury. Now, if that goes to the grand jury and an indictment is returned, and let's say there is no petition in juvenile court, then what I tell people is your indictment right now is meaningless, because the original jurisdiction for that transaction lives in juvenile court. There must be, I think we clearly have law already that there must be a petition that alleges an A through G felony at 16 or 17 in order for that indictment to mean anything. You have that indictment sitting out there and you don't have a petition with an A through G felony at 16 or 17, you can't do anything with that indictment because the original jurisdiction is in juvenile court. So, then the question is, well, what if I only took, like, if I only had a petition on a D, but there are actually 3 other charges in this case? Can I take a returned indictment on the D, because that's the only thing in the petition, trigger the transfer, and now, and have already gone and gotten indictments on all those other charges, even though they weren't in the petition? And I think the law right now says to the prosecutor, yeah, you can, because the whole thing gets transferred, and State v. Jackson tells us that you can add charges that weren't in the petition when you're in superior court. So the whole thing is traveling as an entity, and the thing that matters to trigger the transfer is that you have original jurisdiction over an A through G at 16 or 17, and then an indictment is returned on that offense. And when that happens, the whole thing goes. I think Eric's perspective is different in that he doesn't think anything that is not in a petition should go to the grand jury in an indictment prior to transfer. And functionally, what that means is if the prosecutor wants to proceed in superior court on a charge that was not originally in the petition, they are going to have to go to the grand jury twice. they're going to have to go to the grand jury with what was in the petition to trigger the transfer. And then when they get to Superior Court, if they want to add a charge, which is what happened in State v. Jackson, that was not in the original petition, they're going to have to go back to the grand jury and indict that too. I feel like I now just confused everybody a lot more. So please ask me questions.
Let me just give an example. So if we have a petition for robbery with a dangerous weapon, we can take that to the grand jury, and if a true bill is returned, we can transfer that. With this language, if we wanted to add conspiracy on the front end, we could do that. We could take, when we went to the grand jury with the robbery with the dangerous weapon, we could also present evidence surrounding that conspiracy. And if a true bill were returned, when we went back for that indictment return, at that point in time, the robbery and the conspiracy would transfer. Without this language that clarifies this issue, what we would have to do is indict the robbery with a dangerous weapon, transfer the robbery with a dangerous weapon, and then if we wanted to add the conspiracy later, we'd have to go back to the grand jury again. And so this language would alleviate the need for us to have to go to grand jury twice just to get that conspiracy charge indicted, based on the same evidence from that initial robbery petition.
And so to Jackie's point, I had recommended language to add, for example, so in subsection C, after the word when in the first sentence, when a petition is filed for an offense that constitutes, etc. And then the second sentence, the prosecutor may include any offense based on, the prosecutor may include any offense for which a petition has been filed based on the same act or transition. So that was my recommendation to try to alleviate that problem.
But again, the draft that is presented does track the statute and the case law that is in existence at this point.
Pre-raise the age, correct.
Okay, any further discussion or questions? Okay, thank you all for that discussion. I think it does help clarify some things for some folks at least, maybe. So we have a motion and we have a second on the floor, and we've had discussion. Any further questions or discussion before we call a vote? Hearing none, Kim, if you would call our roll.
Ms. Jamie Souls for Stella Bailey. Ms. Betty Budd. Ms. Tara Callahan.
Tara Callahan, yes.
Darren Campbell. Judge Courtney.
Vote yes.
Bill Davis.
Bill Davis, yes.
Carrie Frank. Beth Freshwater Smith. Michelle Hall. Director Andrew Heath. Krista Hyatt.
Krista Hyatt, yes.
Jennifer Knox.
Yes.
William Lassiter.
Yes.
Jeffrey Ledford. Marty McGee.
Marty McGee, yes.
Carol McManus.
Carol McManus, yes.
Robert Rader.
Yes.
Mary Stansel.
Mary Stansel, yes.
Heather Taraska.
Yes.
Dr. Robert Taylor. Eric Zagra.
So what I'd like to do is I'm going to say yes on the first two parts and no on the third.
Vote complete.
Okay, and did the motion pass, Kim?
Yes,
Kim,
sir.
can you hear me? Okay, thank you. All right, so based on that vote, the motion passes as it was written. Any further from Ms. Green?
No, sir.
All right, thank you for that. Thank you for your presentation and your work on that. And thanks to the work group as well for putting in the time and effort to bring that to the committee. Thank you very much. The next item on the agenda is the minimum age presentation discussion with Judge Corpening and Dr. Cottle and Ms. Green as well. I'll turn the floor over to you.
Thank you, Chairman Davis. The minimum age subcommittee has been meeting since January of 2020. We met a total of 9 times. I want to thank the members of the committee for their work: Tara Callahan, Krista Hyatt, Billy Laster, Carol McManus, Mary Stansel, Heather Taraska, and Eric Zagre. We were also advised through our process by a number of people, including Professor Jackie Green, Dr. Cindy Cottle, Dr. Therese Garrett, Dr. Peter Kuhns, and Dr. Maureen Reardon, and Professor John Powell from Campbell School of Law. We had presentations through our meeting process from a number of subject matter experts, including Jackie Green, who I mentioned. Aaron Hickey did some, with DPS, did some national research for us on minimum age. Dr. Cindy Cottle, Reese Garrett, Peter Kuhns, and Maureen Reardon on pre-adolescent development and developmental intersections with juvenile justice procedures and the impact of trauma on maturity and executive function. And then Professor John Powell on restorative justice. We are making a recommendation today, and Kim, if you can, I guess folks can scroll down document to see our recommendation. Nope, not yet. Kim, can you put up the recommendation from our committee? If not, I can share my screen. We want to talk a little bit today about our work and the minimum age issue has garnered a lot of attention in North Carolina, around the country, and around the world. Part of what we learned in our work is that 22 states in America set a minimum age. One of the significant things about that is that North Carolina sets the lowest minimum age at 6. There are 12 states that set 10 as the minimum age. There are a couple that set 12. We also learned that North Carolina has the lowest minimum age in the world, thanks to some information that Eric Zagre provided for us from the National Juvenile Justice Network. I always get hung up, Eric, on what all those letters stand for. But the United Nations Convention on the Rights of the Child recommended in 2007 that the international, the worldwide minimum age be 12, and then in 2019 upgraded to recommend that the international worldwide minimum age be 14. And right now, the National Juvenile Justice Network is recommending a national age for the United States of 14. The states that don't have minimum age typically don't seem to have standalone juvenile justice systems. They are intertwined with DSS, and just as we were talking earlier in the legislative update by Justin Davis, lots of those states handle younger kids through child welfare instead of juvenile justice setting, and so younger kids don't land in court. We did look at data surrounding the 6 to 9 year olds to see, both how many kids were coming to juvenile court, being referred to juvenile court age 6 to 9, and then how serious were the offenses. For fiscal years 16-17 through 18-19, 1,147 youth aged 6 through 9 received 2,101 complaints. 9-year-olds were consistently the highest in that group, with 85% of all the complaints that were made. Excuse me, 85% of those complaints were boys, were male children during that 3-year period. Most of the offenses were referred to juvenile justice from schools. So during that same 3 fiscal year period, 72% of the case complaints received for kids 6 through 9 came from school. For age 6, it was 92% of 6-year-olds, 81% of 7-year-olds, 74% for 8-year-olds, and 64% for 9-year-olds. In each year that was reviewed by juvenile justice, at least 80% of the complaints for this age group, 6 to 9, were either closed or diverted at intake. During those 3 years, a total of 42 youth ages 6 through 9 were placed on probation, and a total of 12 youth were placed on protective supervision. And again, that's cumulative for a 3-year period. There were no detention admissions for that age group during that 3-year period. And in terms of the more serious offenses, there were 29 distinct juveniles with 58 A through G complaints. Of those, 3 were closed at intake, 2 were diverted at intake. 53 complaints were approved for court, and of those 53 complaints, 45 were dismissed and 8 were adjudicated. All of the 8 adjudicated offenses for the 6 distinct juveniles were sex offenses. 1 was a B1 felony, and 7 were Class C. Much of our discussion also revolved around still trying to serve the 6 through 9-year-olds with juvenile justice services, which led to the process that Justin talked about with the consultation services being available. We did have lots of discussions about parent accountability, but have landed really without that because of the jurisdictional concerns. And special thanks to Jackie Green for having her head on straight and guiding us through those challenging conversations, because lots of us would love to make parents accountable and have a process, but we at the end of the day we struggle with jurisdiction on that. We really wanted 6 through 9-year-olds to still be able to be referred to JJ funded services, for example, JCPC programs, for example, which may be age appropriate for that population. And some of that's designed to address the question that we knew would come up is, well, what are we going to do with these kids? And so, our language contemplates that that services continue to be provided, and that yes, a DSS complaint can be made, or report can be made. School services, mental health services, local programming through JJ services. All of those things need to be available to meet the needs of these kids. We did have lots of discussions and are having ongoing discussions about capacity to proceed. Capacity to proceed and the minimum age are inextricably linked because of brain development and the cognitive functioning of these youngest children. And those discussions led us to at least this first recommendation that our subcommittee is presenting to the Juvenile Jurisdiction Advisory Committee, that capacity evaluations and hearings after those evaluations for youth younger than 12 to be mandatory. We felt it was important to address, based on the experts that we consulted with, that we look at that. Part of our ongoing discussions on the issue of capacity have to do with actually creating a juvenile standard for capacity evaluations in North Carolina for the first time. Right now, our young children are evaluated for capacity the same way that I would be evaluated for capacity. The same test is used, which has honestly never made sense to me. And so we're having ongoing discussions about what that capacity evaluation would look like, who's qualified to do it, and what training can be implemented in order to have qualified examiners across the state. When I started, I mentioned that this has gained a lot of attention, and some of you may have seen the News and Observer article about the 6-year-old who went to court for picking a tulip at a bus stop. You know, when I first talked to that reporter, I was horrified that right now, today, in this world right now, that we would have a 6-year-old referred to court, but it was about 12 to 15 years ago that it happened. But you know, but it has the story went viral, and when I say viral, I mean nationally, even internationally. We've heard from folks across the country about it. I want to thank Jackie Green for her very special words that I have shared very liberally, but it really brings home the point about 6 to 9-year-olds being in court. And you know, so what I shared with that reporter was that should a child who believes in Santa Claus, the Easter Bunny, and the Tooth Fairy be making life-altering decisions in court? Because the frame of reference is that the child makes decisions. You're not Eric or Mary sitting beside them. The child has to make certain decisions because it's their case. They get to decide, you know, whether to testify, whether to accept responsibility for a case. And those are significant decisions. So that's my intro, and I'm going to pass it off to Jackie Green and then to Cindy Cottle for remarks. Thanks again to both of you for your expertise and your willingness to work on this important project. So Jackie, I'll pass it off to you first.
Awesome. Thanks, Judge. I'm not gonna, you'll be glad to know I'm not gonna do a presentation or spend a long time going in the weeds with you on this, but I am gonna pop in the chat right now 2 links. One, because I know you can't wait to read my Juvenile Law Bulletin. It is a Juvenile Law Bulletin that I released not that long ago on exactly this question of the legal issues of including very young children in delinquency jurisdiction. And if you don't want to read the whole bulletin, I can't imagine why you wouldn't, but if you don't want to, you just want to read the blog, there's the link for that too. And I'm just going to give you a couple of quick highlights today. I could talk about this for a long time. I know we don't have a long time left in this meeting, and I know Cindy has some great practical things to talk to you about, and I want to leave time and space for her. I will tell you that the first half of that bulletin is about the issue of the infancy defense, which we don't have anymore. And it traces the history of that. You know, it used to be under English common law, before we had a structured juvenile court system, that if kids did something that was criminal, they were always tried as adults. That was the only court we had. And in that structure, there was this infancy defense, which said kids under 7 could never be tried. They were too young to understand the criminality of their actions. Like when I think about that, I think about like a 3-year-old walking out of a grocery store with a candy bar in their pocket that they picked up at the checkout line, right? We wouldn't think that a 3-year-old should be charged with shoplifting because they don't know, right? So that kind of like, you don't know, or you don't know the criminality of your act was a big thing under English common law. And in fact, there was, so you couldn't try anybody under 7. If you were between 7 and 14, the presumption was you couldn't be tried. It was rebuttable. So you could rebut that presumption, you could litigate that, but the presumption was you couldn't be tried. The presumption was only that you could be tried when you reached the age of 14. And then we got rid of that because we created this juvenile court in 1919. And I found all this history super interesting. I know it's not the point of our meeting today, but what is interesting about it is the infancy defense disappeared. And it disappeared because we stopped asking the question in the first juvenile court, did the kid do it? The first juvenile court wasn't about, are you delinquent? Did you do the thing you're charged with beyond a reasonable doubt, with lawyers in the room, with people testifying on constitutional rights? That is not what the first juvenile court looked like at all. And over time, juvenile court has evolved to that, right? So now we know that kids have constitutional rights when they are respondents in delinquency proceedings. Adjudication requires proof beyond a reasonable doubt. If you were sitting at an adjudication hearing, you'd be hard pressed to find really many differences between a criminal trial and adjudication hearing, except that there's no jury there, really. Kids have nearly every constitutional right that an adult criminal defendant has at trial when they're at adjudication. And so the bulletin walks through that if you're a nerd like me and find that interesting, which I clearly do. And then kind of tracks into, okay, so what do we require of kids who are respondents in delinquency proceedings? Because I think it's real easy for us to, and I know many of you at this point in time, and I know you are all good people who want to do good things for kids, and we think about getting kids services in the context of delinquency proceedings. But delinquency proceedings are adversarial proceedings where the kid is actually in charge of their own defense, right? So they have a lawyer, but that lawyer is an expressed interest attorney. I've been a lawyer for kids, and that is a hard role. You know, you're working to counsel that kid, but in the end, the kid is driving the bus, and it doesn't matter if they are 6 or they are 17. The rules are the same, and they have to make these critical decisions like, should I accept a plea? Should I make an admission? Should I testify for myself? Those are big decisions that require capacity, right? This legal standard of capacity. Now, our capacity standard in North Carolina, as Judge Corpening said, we use the adult capacity standard. It is incorporated into our juvenile code. I write a bit in the bulletin about how that I think is probably constitutionally suspect, given the line of U.S. Supreme Court jurisprudence about how the fact of childhood is quite important when we analyze constitutional rights. Our statute doesn't do that right now. It is the adult standard. And it requires that kids understand the nature and object of the proceedings, that they comprehend their own situation in relationship to those proceedings, and that they can assist their attorney in a rational or reasonable manner. I live with a 7-year-old. She is the light of my world. I'm not sure how rational or reasonable she could be in assisting a defense attorney, but she is lovely. So those are the standards that we have for young people, like I said, regardless of if they're 6 or 17. So the question then becomes, could kids under 10 ever be competent in that way? Could they ever really have capacity? And I think Cindy can talk a lot more with you about what that looks like on a practical, functional basis for very young children. But I'll tell you that conclusion I drew in my bulletin after looking at the law and the social science was it's very hard to see how very young children could have legal capacity. And the other thing I did along the way in working with the minimum age subcommittee and supporting that work was I did some looking at a bunch of the other states that don't have minimum ages. Because, you know, often when people throw that data up and it's like, oh, but the majority of states don't have a minimum age, so North Carolina really isn't that bad. When you dig into their statutes, they don't have a minimum age, but many of them have capacity statutes that say you must take age and or developmental maturity into consideration when you think about capacity. So functionally, they're not trying very young children in those states as juvenile delinquents, because in the end, and I guess this is what I'll leave you with so Cindy has some airtime. In the end, it's important to remember that really these are proceedings with trials where we are expecting the respondent, the juvenile, the kid, to make the critical threshold decisions about their legal case. And it's really important to know that kids are developed enough to be able to make those decisions in a way that meets what is a U.S. constitutional standard of capacity. So I'll stop there. I know you're all going to rush to read that bulletin. It just warms my heart. And I'll toss it to Cindy.
Thank you, Jackie Green. And I want to make sure everybody can hear me before I get too far.
Yes.
Kimberly, I had texted you a couple minutes ago saying that I can't share my screen without rebooting my computer, and I don't know if you're able to share my slides for me. If
We
not,
sure
I
will.
can. I don't have to have the slides. There's a couple of charts that are a little bit easier to talk about. There we go. Jackie, I want to commend you on your bulletin, actually, and I reread it again yesterday. It's really, really thorough in terms of the history, but also really describes the research and the concepts that I'll overlap with yours a little bit. And I do actually reference yours in my talk today. It's a really good article. So I'm going to talk with you today about some of the research surrounding adjudicated competence or competence to stand trial in adolescents, specifically in the younger age group. And if you'll go to the second slide, I will first give you an overview of how the current statute is translated into psycholegal constructs that we as mental health professionals, actually, I think I can, can't I? Yes, I can. Okay. That we as mental health professionals use to assess these capacities. I'll summarize some of the primary areas of development that are associated with adjudicative competence. And finally, I'll summarize some of the research, what little research there has been done with that younger age group. So as Jackie just mentioned, I won't read this to you, but this is the language. I will point out that this is the same standard that is used for adults and the same standard that I use when I evaluate someone for capacity, whether they are adult or juvenile. This is the standard that I am required to reference. So how do I translate that into an evaluation? If you look at each column, the first
Cindy,
column, yes?
Cindy, can I interrupt 1 second? So this is
Sure.
another file share example. On the left, if folks hover over the left-hand side, there is a bar that appears, and you can page down there to look through the slides.
So I've been sliding down and no one else has.
That's
so
correct.
We should be, okay, I got you. So we should be on the slide that says translating capacity to proceed. And there's a table there. So I'm going to assume that everybody has probably found that. I see thumbs up. I'm going to keep moving. If not, it's okay. You should be. That's what I say pretty well. So each of the columns describes the main components divided into 3 groups. The first, understand nature and object proceedings. It's the factual understanding. There's a little overlap in these. That pertains to the basics, the terms that a juvenile will hear in court, which as an evaluator, I'll say, and I think Mr. Lassiter agreed with me once before, that the language in the juvenile system just seems to be more complex than the language and the concepts in adult system, which adds to the nature of the evaluation. So for example, when I'm doing one of those evaluations with an adolescent, I have to ask them about a transfer hearing. I have to ask them about words like adjudicative and disposition and things that are a little different than in the adult system. In the rational or comprehensive situation in reference to the proceedings, that pertains to the rational understanding and appreciation. Some of those kinds of things that I might look at is their ability to weigh facts, to weigh short and long-term consequences, to understand the adversarial context, but also the quote friendly court as well. It's a really complex situation. One of the questions that oftentimes is very confusing in these evaluations is when I ask about the roles of the various court personnel. They usually get the judge, and sometimes they get the attorneys. They might mix them up, but then they kind of get that right. But then when I ask about the juvenile court counselor, it throws them. And sometimes, you know, they're like, well, that's like my social worker, or it's my probation officer, or it's a difficult concept to ask about. The third column there pertaining to ability to assist. With adolescents, particularly the younger ones, some of the things that come up is their ability to pay attention and maintain self-control, to testify, to communicate and trust their attorney, to manage the stress and make decisions. The last row in that table pertains to some of the potential problems. Of course, in North Carolina, our current statute limits the reasons that a person can be found incompetent to proceed are mental illness and defect, and that just boils down to mental illness or mental, what used to be called mental retardation or intellectual disability. Our current statute doesn't allow for developmental age or immaturity to be a reason that a person lacks capacity. Those I've noted here, and I'll summarize some of those studies a little bit later. The deficits sometimes are not necessarily related to a mental illness or intellectual disability. Sometimes it's because they're 7 or they're 8. I don't even know that it's because they're immature. They're just 7 or 8, and that's who they are. Sometimes it is immaturity, and sometimes there's certainly some overlap as well. So if you guys will go to the next slide. This is just another version of that table that I've used before to explain how an evaluator might go about assessing each of those components. I won't go through these right now. I will highlight, though, that one of the recommendations that had been mentioned and that I will also recommend is using developmentally appropriate assessment methods and tools. I will say conducting evaluations of adolescents, particularly the younger group, is quite a bit more difficult and requires more comprehensive evaluation process than adults by far. Oftentimes it requires more sessions than it would for an adult, because sometimes I like to assess whether or not they retain new information that I may have taught them or given them over time. And then can they apply it to their case in a reasonable manner? And I'm also looking at that bottom row where it says capacity to learn. That's one of the things that I also evaluate as well, is what degree of remediation would be required if that person is not competent. And remediation may not be really the right word for some of these cases, but could they attain competency? And if so, how long might it take for them to do that? So scrolling down to the next slide. Now we're going to look at some of the research in this age group. But first, there's some basics that are important for you to remember throughout this section. There are, let's see. Second, let's make sure that didn't skip anything for you, or then I'm on the same slide that you are. Okay, yeah, so these are some of the truths or basics of adolescents at all age ranges. Certainly those that we're talking about, the 10 and younger, are going to be a little different. But when Thomas Grisso is one of the primary researchers that has done a lot of work in this area in terms of the capacity of adolescents. And these are the themes that come about. And when I use the juvenile instrument that he developed years ago. These are some of the factors that he recommends that evaluators consider. So autonomy or independence. And again, there's that independence, like somebody had talked about earlier, from their parents as well, and their ability to make independent decisions. And do they realize that they have that capacity and that right? Do they acquiesce to authority? Perceptions of risk. We see that all the time. They are more likely to take risks when they're younger. That has to do with some of the limbic system, risk reward system in their brains. Time perspective, their sense of time is skewed. And so we all know when you talk to an adolescent, for example, and they say it's been a really long time. You really have to define that, because that can mean a number of different things depending on what they're talking about. But that's also important when you're talking about when they're, I'm assessing a juvenile, for example, who might say, I can't be in detention for another month. I'd rather just plead guilty or whatever, just so that I can get out now. And so that's important to look at what, why they make the decisions that they make, and is it related to one of these factors. Abstract and concrete thinking. Kids in that age range from 10 and below, they are really going to be a lot more concrete. And they're going to have difficulty thinking in hypothetical terms, drawing inferences. And certainly with self-regulation, that group as well. I've done evaluations walking in circles in my parking lot because the kid couldn't sit still. We've played Legos. There's been some situations that arise in those evaluations that don't otherwise arise with adults usually, just by virtue of them being quite young. If you'll go to the next slide. These are some of the same concepts, but other researchers in the, they have also recognized these same trends. They might call it something slightly different, but these are the overall themes, if you will. And so the next slide, where it says summary of research studies investigating, oops, here we go. Investigating competency stand trial in young adolescents. Now, there's just not many studies pertaining to younger groups. There weren't many studies pertaining to adolescent capacity to proceed to trial for many years anyway. It's only been since the 1990s or so that any were done, and only 25 since 2000. I did find a summary article, which I've got some references at the end, where they talk about, over a 10-year period, concluding. And that was a particularly helpful article as well. There's not many, and why is that? Well, because in truth, there aren't many places where adolescents or children ages 10 and below are required to attain capacity, or where they're being assessed. And in general, a lot of researchers and lawmakers have determined that children in that range are not competent simply by virtue of their age and or immaturity. Where there have been studies, usually the ages have typically been somewhat older, like in the 11 to 13-year-old range. So I will talk about some of those studies. And sometimes the studies don't really separate, as cleanly as 10 and younger. They might, go, 9 and above or what have you. A couple of things to keep in mind: there's no specific age at which any researcher has said this is when there should be competent. One reason for that is because there's just so much variability at the earlier ages than at older ages or adults, between individuals, but also within a given individual. There's a lot of variability in abilities. So let's see. Adolescents are, above all, more reactive and affected by situational factors of stress and emotionality and charged in emotionally charged situations. So even adolescents, and this is important, even adolescents or children who are otherwise highly rational, logical, in some contexts are likely to lose those capacities when they're in a stressful situation or in an emotionally charged situation. And that explains some of the inconsistencies and the, why sometimes they understand it and other times they don't. And on the next slide, it's another table. And Jackie, your summary also talks about many of these as well. And then that 10-year study, which is the Cunningham Study, talks about these same ones. When I say there are very few studies, there really are only a handful. And by and large, like I said, they focus on a slightly older age group. But what it does say is that children younger than 10 typically are not viewed as competent, and most of them are adjudicated incompetent. They're more likely to have difficulties with the most basic level of understanding, that factual understanding prong. Therefore, they're likely to also have the problems with the more, with the appreciation component and the ability to assist. Those younger groups also, like I said, tend to have problems with sitting still and with paying attention. So some of the findings there. The reason for the lack of competency for this group is simply age, like I said, and I'll note again in a couple minutes. And this is important as well. I've actually heard another expert testify that, experience in the court system probably helps them. And that is not true. Researchers have found that just experience in the court or just attending court hearings repeatedly does not necessarily lead to improvements for those kids. It might for some, but it doesn't for everyone. Now, the impact of age on abilities is significant in another way. So if there is a limitation present, say attention or inattention, then youthfulness really does magnify that effect. So it's more significant, more apparent for kids who are younger than those who are older. They can't make up for it in some other way, if you will. So if you'll go to the next slide, I talk about intellectual functioning. So likewise, adolescents with intellectual deficits tend to have deficits in understanding legal competencies, and that affects younger adolescents. So if there is you see people who may not have an intellectual disability, but they have a lower IQ, that's going to affect younger groups more so than it would older. A few other findings of interest. Youths who had previously received mental health treatment have been found to be more likely to be adjudicated competent than those who hadn't. Of course, youth between 11 and 13 are less likely to focus on long-term consequences of their decisions. That's one that, and I added that here because that comes up a lot in the evaluations that I've done. And then the last, I think this is the last major slide here. Based on the studies, what do researchers recommend? Well, they recommend the presumption that youths age 10 and under are incompetent. Or another researcher, Abrams, that third bullet there says there should be an age limit under which a juvenile would not be involved in the justice system at all, but would be served through other systems. They also recommend, as do I, evaluations of competency for all youth under a certain age. And I would add to that, and I think that some other researchers have as well, that those evaluations be conducted by professionals who have experience and expertise in conducting developmentally appropriate evaluations of competency, and that it not be an evaluator who simply has experience with forensics and with an adult population. They're two completely different types of evaluations. They also recommend that statutes allow for developmental immaturity or developmental age as a cause of competence and not just mental illness or defect. And I cannot reiterate that enough as an evaluator. I don't, you know, I have seen cases where a person, a child does not have a mental illness or defect, if you will, and yet they don't have the capacity, and that creates a problem. And then they also recommend education and training about maturity and developmental factors so that youths are afforded developmentally appropriate protection and treatment. So I think that's primarily, can go, there's one more slide that probably summarizes some things that I just said, but and then I've got a range of references, including there's a video, a link to a video, yes, so from the Juvenile Justice and Adolescent Brain, where Thomas Grisso and a number of other people speak, and then the 10-year update and some other references as well. So that is the bulk of what I have. Any questions?
Thanks, Cindy, for that great presentation. Chairman Davis, you've got the recommendation from the minimum age subcommittee, and we'll ask that a vote be taken on that recommendation.
Okay, thank you all for your committee's work and the presentations that we've heard today. We have as a subcommittee motion, that would be a motion on the floor. Do we have a second for that motion?
A second.
Okay, we have a motion and a second. And is there any further discussion or questions on the motion that's on the floor? Okay, hearing no further discussions or questions, then I'll ask Kim to handle the vote.
Calling for a vote regarding the language on raising the minimum age of juvenile jurisdiction. Ms. Jamie Souls for Stella Bailey. Ms. Betty Budd. Ms. Tara Callahan.
Tara Callahan, yes.
Darren Campbell. Jay Courtney.
I vote yes.
Phil Davis.
Phil Davis, yes.
Gary Frank. Beth Freshwater Smith. Michelle Hall. Director Andrew Heath. Krista Hyatt.
Yes.
Jennifer Knox.
Yes.
William Lassiter.
Yes.
Jeffrey Ledford.
Yes.
Marty McGee. Carol McManus.
Yes.
Robert Rader.
Absolutely, yes.
Mary Stansel.
Yes.
Heather Taraska.
Heather Taraska, abstain.
Dr. Robert Taylor, Mr. Eric Zagra.
Yes.
I'm counting the yeses. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and 1 abstention. The motion is passed.
Okay. Thanks everyone for that. The motion on the floor passes. And thanks for the subcommittee for all your work again, and for our presenters that presented today. Thank you for the good information. The next item on the agenda is the new business. Does any of the members have any new business that we need to bring up today? Okay, hearing none, we'll move on to the public comments. Kim, do we have any public comments that you're aware of?
No public comments have been received.
Okay, thank you for that. Our next steps are, our next meeting, I think Kim had suggested that we might meet July the 7th to the 16th. Is that correct, Kim?
July the 16th, that's correct.
Okay. And looks like we would be, hopefully we'll be able to meet in person that day from 10 to 2 at Hammond Business Place. Is that correct?
Yes, sir.
All right. All right. So that would be our next step. That we'll have our next meeting by then, and hopefully that will be in person unless things change. That will be the plan for this meeting at this time.
Bill, I'd just like to add that I'll be scheduling a legislative revisions and legal issues subcommittee meeting in advance of the July date.
Okay. Thank you for that. Any other subcommittees that want to make any announcements about activity?
Chairman Davis, the minimum age committee is going to continue to meet. We were actually going to meet today, but canceled it at this meeting. So we're going to continue to meet.
All right. Thank you for that, Judge Corcoran. And any other committee meetings that need to meet? Okay. Well, thank you all for your time and your patience today. We went over a little bit, but it was very important and very good information, I think, that we heard today. And I'll entertain a motion that we adjourn.
Motion to adjourn.
We have a second.
Second.
All right. All in favor, say aye, and we'll adjourn.
Aye.
Aye.
And see you later.
Thank you.
Thank you.
Work, everybody.